My name is Professor Cseet Nov from K SHAH Classes. So let us continue legal aptitude revision, and in today's session we are going to cover, that is, elements of company law. Yes. So friends, as you know, yesterday we have already done Indian Contract Act 1872. I hope you all have already watched the video of yesterday's session, in which we had discussed 80 MCQs, and that session was not covering only MCQs but revision of all the topics, right? So today we are going to cover elements of company law. Yes, you know, this chapter is very important. Exam point of view also, knowledge point of view also. All my CS aspirants, you know, the role of CS is directly connected with Companies Act. Yes, as a CS is a legal advisor for the companies, right? So friends, now let's go. Let's start without wasting any time. So are you all ready? Can we go ahead? So once again, good luck to all the Yodhas, and let's begin with the chapter Elements of Company Law. Yes, so the first question, which one of the following is known as the owner of the company? Who are called as the owners of company, friends? Come on, who is the owner of company? So very simple, you all know that owner means, yes, who is called as the owner of company? You know friends, very simple answer is shareholders, right? Debenture holders in the option A, you can see obviously debenture holder are the creditors of company. Then board of directors, these are called as the managers of company. Shareholders are the owners of company, very simple. And partners, there are no partners in company, there are shareholders. So option C is the right answer. Yes, come on, next question is talking about articles of association of company contains the name of dash. Firstly friends, what is this articles of association? You know friends, every company have its own constitution. Yes, what is called as the constitution of company? So answer is Memorandum of Association. Yes, you must have heard about this. MOA is the constitution of company, the constitution document of company, right? On the basis of constitution, yes, what do we make? We make rules and regulation. Obviously the rules and regulation shall be as per the MOA. So what are the rules and regulations of the company? So rules and regulations of company means articles of association. Okay, so AOA should be prepared in line of MOA. Obviously AOA is subordinate to MOA. Okay, and obviously when I say AOA are the rules and regulations for the internal management of company, which means who will follow the rules? Come on, tell me, who will follow AOA? So answer is the people who run the business of company. So who run the business of company? So obviously answer is directors. Yes or no? So directors are the people who run the business of the company, right friends? So directors are subordinate to AOA, AOA is subordinate to MOA. So that way it goes. So friends, now the question is, the articles of association of company contains the name of dash. First director, subsequent director, shareholders, managers. What is the answer? So you know friends, these two documents, MOA and AOA, these two are called as the charter documents of the company. Okay, and we prepare both the documents at the time of incorporation of company. Whenever we do registration of company, incorporation of company, at that time we prepare MOA and AOA. Okay, so when we, obviously this question is taking us to a topic that is incorporation of company, and when we make application to ROC, you all know that we have to make an application to ROC in SPICE plus form, SPICE 32, right? So in form number 32 we make an application to ROC for registration of company, right? Along with that, we need to attach certain documents, and those documents include MOA and AOA also. I repeat, it includes MOA and AOA also, right? And when we prepare the AOA, in that we have to mention who is the first director of the proposed company. Who is going to be the first director of the proposed company? So what is the answer? Yes, answer goes to the first director of the company. So answer is A, the first director of the company. Easy. So I hope this is clear to everybody. So second question is also done. Next one is, dash is called a body corporate because the person composing it are made into one body by incorporating it according to the law and clothing it with a legal personality. Now you know friends, there are two things. Firstly, there is something called as company, there is something called as sole trading concern, there is something called as partnership firm and HUF also. When you compare all these forms of business, you know the features of company. Yes, the features of company says that company is a separate legal entity, company has a corporate personality, once the company is registered, then company gets its own existence and etc etc. Yes or no? So all these things we understand, right? But tell me, is partnership firm a separate legal entity? No. Can partnership firm have the feature of perpetual succession? No. You know, when the partner dies, in such case what happens? Partnership firm also dies. Yes or no? So similarly the things goes, but yes, here in the question you can see they are asking about, it is a body corporate where the person composing it are made into one body by incorporating it and giving a legal personality. So definitely this features which you can see here, legal personality, separate legal entity, right, created by law and body corporate, this is directly connecting us with the option B, that is company, because no other form of business have such features. So I hope this is clear to everyone. Yes, come on. Next is, what is known as a charter of a company? Yes, what is known as the charter of company? Memorandum of association, bylaws, articles of association and prospectus. So friends, when we say charter of company, means what? You know friends, every company have its constitution document that is called as MOA. Yes, MOA is a constitution document of company, and along with that we also call it as a charter document. So answer is option A, memorandum of association. Okay, yes. Otherwise, articles of association are the rules and regulations of internal management of the company. They are also called as the bylaws of company, and prospectus is totally a different concept. So I hope this is clear to everybody. Yes, we move to the next one. Which of the following is a tribunal under Companies Act 2013? Yes. So friends, as you know, if all the company law cases, all the company law matters are referred to which authority, which adjudicating authority? So answer is obviously NCLT, that is National Company Law Tribunal. I repeat, National Company Law Tribunal. So answer is option A, NCLT. Okay, so I hope this is clear to everybody. The others you can see, Central Appellate Tribunal, Competition Appellate Tribunal, TRAI, that is Telecom Regulation Authority of India. So all these are also the regulators, authorities, but our answer for Companies Act is NCLT, National Company Law Tribunal. Yes, you can see this question was asked in CSEET e-bulletin in May 2022, right? So yeah, let's go to the next one. A company dies with the death of its shareholders. What do you think? Is this correct? Company dies with the death of its shareholders. True, false? What do you think? What do you think, friends? Obviously, this is absolutely false. Why? Why this is false? Because friends, company is having a feature of perpetual succession. What does it mean? You know friends, members of company members may come, members may go, but company goes on forever and ever and ever. Basically, I mean to say is the existence of the members of company does not decide the existence of the company. Yes, means if the existence of the members is affected, it does not affect the existence of the company. Okay friends, so that way it goes. A company dies with the death of its shareholders, so answer is false. I hope this is clear. Yes, next is a basic document of company generally are dash. What are the basic documents of a company? Annual accounts, prospectus, minutes of meetings, MOA and AOA. Come on, what are the basic documents? You all know the answer, we all know the answer. Answer is option D, MOA and AOA. You know, because these documents are like MOA is a constitution document, AOA is the rules and regulations. Very simple, right? So yes, these are the basic documents. Next one. In case of loss to a limited company, liability of shareholder is dash. See, here you can see here we are talking about a type of company that is a limited company. Okay. Now see friends, if I need to explain this limited company, what it is. Limited company means what? Friends, in limited company, obviously the liability of the members of such company is limited, correct? But how much? So in limited company there are two subcategories. One is company limited by guarantee and another is company limited by shares. Company limited by guarantee and company limited by shares. Okay friends, so what it is? See, when I talk about the subcategories, obviously both are subparts of what? Limited company. That means in both the subcategories the liability of the member is going to be limited. But how much? So if we talk about company limited by guarantee, in that case the liability of the member is going to be limited, but up to what extent? Only up to the extent of amount of guarantee taken by the members of company. Yes, I am talking about company limited by guarantee. Okay, because you know in this case the members of company, they undertake guarantee of a certain amount. Yes, in company limited by guarantee, the members undertake guarantee of a certain amount. And that amount, what is that guarantee amount? Obviously that is mentioned in the liability clause of Memorandum of Association. Okay friends, so whatever the guarantee amount member has undertaken, that is going to be what? That is going to be the liability of the members. So obviously liability is limited in that case. How much limited? Only up to the extent of amount of guarantee taken by them. Okay, so that is limited. That is up to the extent of amount of guarantee taken by them. Okay. Next case you can see friends, company limited by shares. In this, what is going to be the liability of member? So in this case the liability of member is going to be, the members are liable only up to the extent of unpaid amount on shares held by them. Like you know, suppose if one share price is 10 rupees, 10 rupees per share. So what do we do? First we pay application money, then we pay allotment money. Let's say application money was 2 rupees per share, then we pay allotment money 3 rupees per share, then we pay first call money, that is let's say again 2 rupees per share, then there is second and final call money, that is 3 rupees per share. Okay, so this way it is. Now friends, suppose if already members have paid application money, yes, allotment money, yes, first call money, yes, Second and final call money, the amount is still pending. Okay, so you can see 2 plus 3 plus 2, 2, 3, 2, that is 7 rupees. Out of 10 rupees, 7 rupees is already paid up. Okay, and 3 rupees is unpaid. Okay, so friends, if I am the member of this type of company, what is going to be my maximum liability? Actually, I'll tell you one secret. I'll tell you something. Listen to me. I am the member of Reliance Industries Limited. Yes, I am the owner of Reliance Industries Limited. I am the owner of Reliance Industries Limited. Yes, right now you are attending a session with the owner of Reliance Industries Limited. So one day, Mukesh Ambani ji called me and he told me that, okay, you are the member, you are the owner of the company. I told yes. So he told me that, see, company has suffered so and so amount, X amount loss. So you are the owner, you are the member, therefore your share in the loss is 50 lakh rupees. So kindly come and pay the contribution in loss. So what do you think, friends? Do I have to pay 50 lakh rupees? Do I have to contribute in the loss? So answer is no. Why? Because Reliance is a limited company. So in that case, what is going to be my liability? My liability is going to be limited. Up to what extent? That is only up to the extent of unpaid amount on shares. What is the unpaid amount here? That is 3 rupees. I have to just pay 3 rupees per share, which is my unpaid amount on shares. Because out of 10, 7 is already paid up. I just have to pay 3 rupees. Because I am liable only to pay the amount of shares what I have subscribed for. Right? So this way it goes. I hope you are clear. So now if we go to the question, in case of loss to a limited company, the same example as I told, the liability of the shareholder is going to be dash. What? Limited or unlimited? Firstly, in the question itself they have given it is a limited company. Therefore, liability of the shareholder is going to be limited. So no chance of unlimited, right? So what it is? Come on, limited to the amount as they have declared, limited to the amount of capital to which they have subscribed, limited to its secured debts. So answer is option C. Option C is the answer, that is limited to the amount of capital to which they have subscribed. That is unpaid amount, nothing else. Okay, one more thing, friends. If 10 rupees per share is the price, and what if I have paid the entire 10 rupees? I have already paid entire 10 rupees. Then in that case, what is going to be my liability? Answer is nothing, because my liability is only up to the extent of unpaid amount on shares, which I have already paid. So no more liability for me. Right, so that is the case. I hope this is clear. We go to the next one. Every company, public or private, has to be registered with dash. So very easy question. Where do we have to go for registration of company? So obviously answer is ROC, that is Registrar of Companies. Registrar of Companies. Yes. Then there are state-wise ROCs, Registrar of Companies, and there are 2 states where there are 2 ROCs. One is Maharashtra having 2 ROCs and another state is Tamil Nadu having 2 ROCs. Okay. Yeah, let's go further then. Very simple question, 9th one. Now 10th one. As per section 203, what is 203, friends? 203 talks about appointment of KMP. Appointment of KMP. Okay. So as per section 203 of Companies Act 2013, read with rule 9 of Companies Appointment and Remuneration of Managerial Personnel Rules 2014. Who among the following is not a KMP? Who among the following is not a KMP? So if we need to answer this question, firstly we should see this question was asked in CSET November 23 attempt, right? And secondly, who all are considered as KMP? So if I go to the definition of KMP, it is given in section number 2, clause number 51 of Companies Act 2013. Okay, so as per the definition, who are considered as the KMPs? So answer is Managing Director, Whole-Time Director, Manager, CEO, CFO and Company Secretary, right? And such other person as prescribed. So basically the 6 people are considered as the KMPs as per the definition of KMP. So come on, CFO, Chief Financial Officer, was a part of KMP? Yes. Whole-time Director was a part of KMP? Yes. Managing Director, MD, was a part of KMP? Yes. Principal Legal Specialist? No, he was not a KMP. So who among the following are not a KMP? So answer is option C. Okay, now see friends, right now you are studying this section number 203 and you are studying this in such a summarized manner. But friends, when you go to CS Executive, you are going to study company law very much in detail. You know, the company law is a entire paper, entire subject for 100 marks in your executive. And yes, it is my subject. Okay, so I wish to teach you all company law in executive if you people give me a chance. So it is very much in detail, but it is very interesting as well. Okay, let's go to the next one. The case Salomon versus Salomon and Company Limited led which of the following characteristics of company? Yes, the Salomon versus Salomon and Company Limited, very famous case law. This case law explains us what? This case law explains us corporate personality. This case law explains us that company is different from the members forming the company. Company is different and members forming the company is different. Right? Why that is the case? Because company is having its own existence. So company is different and member is different. So obviously the case law is explaining us the corporate personality feature. Okay, so that is the case. Yes, next one. The company consists of heterogeneous members, whereas dash consists of the homogeneous members, since it consists of the members of joint family itself. So what do you think? It's a very simple question. So Hindu undivided family, partnership firm, LLP, needy company. Very simple answer. Yes, almost everyone's answer is absolutely correct. Answer is HUF, Hindu undivided family. It's very simple. You know, in Hindu undivided family, who is the member of HUF? So very simple answer is the family members. So itself they have given in the question that it consists of the members of joint family itself. So it is HUF, Hindu undivided family. Next. A company is required to spend in every financial year at least a dash of the average net profits of the company made during the 3 immediately preceding financial year in pursuance of its CSR policy. What is this? You know friends, CSR, Corporate Social Responsibility. In this, we directly go to section number 135 of Companies Act 2013. 135 talks about CSR. When you people come in executive, CSR is going to be a chapter in company law paper, and CSR is going to be a subject, entire subject in your CS professional, right? But right now, to answer to this question is, see, whenever company, what is CSR? Company makes profit. So out of that profit, company have to spend a certain amount for the benefit of society. That is called corporate social responsibility. You must have seen there are so many companies, you know, the benches in the park, the dustbins at railway stations and different places. You must have seen there, they have written that the name of the company, and below that they have mentioned it is a CSR initiative. So that way they, you know, they put dustbins, they develop gardens, they give donation in different types of funds. Like one of the example is PM Care Fund. See, obviously company cannot spend its amount out of net profit anywhere they like. There are rules for that. Yes. So CSR rules talks about how that money can be spent, where that money can be spent. So just for your knowledge and revision, company can spend the amount only in the activities, only in the funds. Company can give that money only in the funds and activities which is mentioned in schedule number 7 of Companies Act 2013. You know, Companies Act 2013 is having total 7 schedules. Total how many schedules? Total 7 schedules. Okay, so friends, in that, yes, in 7 schedules, the activity where company can spend money in the form of CSR is schedule number 7. So that was where money can be spent. How money can be spent, that is given in the rules, so many points. And here they are asking how much money to be spent. So answer is company have to spend in every financial year at least 2% of the average net profits made by the company in the preceding 3 financial years. Like for example, see what you need to do first. You need to take out the average net profit of the company made by the company in the preceding 3 financial years first. Okay, so first you need to see net profit made by the company in year 1. Okay, the preceding year 1, that is previous year 1. Okay, plus net profit made by the company in year 2 plus net profit made by the company in year 3. Okay, so previous year 1, year 2, year 3. So when you take out the 3 years net profit, you need to take out the average. So you need to add all the 3 amount and divide by 3. So answer what you get is, this amount is your average net profits made by the company in the preceding 3 financial years. In the preceding 3 financial years. Okay, so tell me, do you need to spend this amount in CSR? Obviously no. How much amount you need to spend is 2% of average net profit. So whatever answer you are getting here, you need to take out 2% of that. Okay, so 2% of this amount is going to be this, and this is your CSR expenditure amount. So company need to spend this amount. Okay, that is the amount which company will spend. So it is 2% of average net profits made by the company in the preceding 3 financial years. Okay, so answer is 2%. So I hope you have recollected CSR provisions. Yes, let's go to the next one. Next one again, Salomon versus Salomon and Company Limited is a classic illustration of which feature of the company? Come on, transferability of shares, perpetual succession, can sue, be sued, separate legal entity. So obviously the answer is separate legal entity, because I told you in this case it is explained that company is different and member is different. That is, it is explaining us how company is having its own existence which is different from its members. Okay, so yes, so option C is the answer. Next, which of the given is not a distinction between company and partnership? Okay, which of the following is not distinguished? Let's see. If we see that first one, company is not a distinct legal person, partnership is a distinct from the several persons who compose it. So obviously in option A, we can clearly see that this is incorrect, because it is saying that the company is not a separate legal entity, but actually it is a separate legal entity. Okay, so I have already decided to mark A as my answer. Let us read the other options also. So option B is talking about what? See the option B, in a partnership, the property of the firm is the property of the individuals. That is, property of the partnership firm is the property of the partners. And in company, the property of company belongs not to the individuals but to the company. So option B is correct, no problem in that. Then option C, a partner cannot contract with its firm. True. A partner cannot enter into a contract with its partnership firm. True. Why true? Because partnership firm is not having a separate legal status. Yes or no? Yes, the partnership firm cannot have its own existence. So therefore, obviously that is also correct. And here they say that a member of company can. So partner cannot enter into a contract with its firm, but members of company can enter into a contract with the company. So obviously option C is also the correct distinguish. Then option D, a partner's liability is always unlimited. True. The liability of the partners in partnership firm is unlimited. Whereas the shareholders may either be limited by shares or by guarantee. Right? So here in the question they have asked which of the following is not a distinction. So answer is option A, because option A, the option you can see, is incorrect. Done? Yeah, let's go to the, you saw this question was again in the CSETE bulletin, May 22. Come on, next one. Who can't use the terms limited and private limited? Okay, which entity cannot use such terms? Firstly, friends, if I explain you, see the two types of companies, private company and public company. Okay, in private company, we always use the word PVT.LTD at the end of the name of the company. In public company, we use the word only limited, only LTD at the end of the name of the company, right? So private limited and only limited, right? But you know, friends, there is a company where no such words are used at the end of the name of its name, right? So what is it? Obviously that is a company having charitable object, company which is registered under section number 8, company which is registered under section 8, that is NPO. So yes, so I hope you got the answer. Answer is option B, that is section 8 company. Yes, are you all solving along with me, friends? Yes, you can definitely write the options in the chat box so that I can see what answers you people are giving, and also please understand the reason of each and every MCQ. Yes, can we go ahead? Yes, I hope you have understood this. Let's go. Which type of company is newly incorporated in Companies Act 2013? Which is the new type of company? So it's one person company, private company, needy company, government company. What is it? So friends, let me tell you, you know, outside India, in different countries have different company law, right? Corporation Act and different things. So in many countries the rule is, you know, even a single person can form a company. Many countries company law is saying that a single person can also incorporate a company. But in India there was no such option. Why? Because in India, to incorporate a private company you need how many members? You need minimum 2 members for private company. For public company you need minimum 7 members to incorporate a company. 2 or more, 7 or more. But what if a person is a single person wants to convert his business into a company? Can he do so? So in India there were no options earlier, right? But when Companies Act 2013 was in force, in that a new type of company was formed, that is called as one person company. Yes, a type which was newly incorporated in Companies Act 2013 is one person company. This is one person company means what? See, it is a company firstly other than public company. So it's very clear that this is not a public company. Okay. And this one person company was formed, it is having the features of both. It is a combination of sole trading concern plus company, that is corporate structure. Okay, so having the features of these two combinations made one person company. One person company was formed with this. Okay, so I hope this is clear to everybody. One person company, sole trading concern and company. Easy? Any doubt in this? Yes. So that was the thing. Okay, I need to discuss one more thing, friends. As I told you, in one person company, tell me how many members are there? Minimum number of members in one person company is 1. Okay, maximum number of members in one person company is again 1. Because if it is having more than 1 member, then how it is one person company, right? So only 1 member will be there in one person company. Okay, but friends, the question is, what if that single person, a one person, what if he dies? So what will happen to the company? You know, friends, if that sole member, that single member, if he dies, so in one person company, in fact only in one person company, there is a concept of appointment of nominee. In 1% company, we appoint a nominee always. So if that sole member dies, that nominee becomes the member. That nominee becomes the member. Is this clear to everybody? Yes. Who can be that nominee? So any person other than minor can be appointed as nominee. Who is that nominee? Who, like for example, if there is a 1% company, so who is the nominee for this 1% company? How we will come to know? So the name of the nominee is written in the memorandum of association of that 1% company. Then that the name is written where? In name clause? No. That is written in the succession clause at last. In succession clause, the name of the nominee is mentioned. That is the person who is going to become the member if that sole member dies. So that is the concept of 1% company, which was newly introduced in Companies Act 2013. See, this question was asked in CSET mock test, right? Yes. So I hope you know everyone is aware about the mock test. Yes, the mock test is you can say a kind of preliminary exam which is conducted by ICSI, Institute of Company Secretaries of India, and you will receive the intimation about it from ICSI also. You will receive an email for the same. So I request each and every one of you to please attend that mock test, right? And that mock test is conducted in the same manner as your main exam is going to be conducted. So you are going to experience that also, how your actual exam is going to be, because CSET is an online exam, as you know, right? So it is a good practice for you. And secondly, you also have to attend K SHAH classes preliminary exams. Okay, yes, the dates will be announced very soon. Dates are going to be obviously after we finish the Yodha series. Okay, so let's go. What is the minimum number of persons and directors respectively required to form a public company? Now friends, in this, if we talk about a public company, so let me tell you, in a public company, how many members are required to start a public company? So I already told you here, for a public company you need 7 or more persons. Minimum members required is 7. Okay, and how many directors are required? This is minimum number of members, right? What about the minimum number of directors? So friends, if we talk about directors in private company, again answer is 2. Minimum 2 directors are required in private company. Okay, and minimum 3 directors are required in public company. Okay, so that way it is minimum 2 directors in private, minimum 3 directors in public. Okay, and if I talk about the maximum number of directors, so that is going to be, for private company it is 15 maximum directors I am talking about, and for public company also it is 15. Okay, because you know, for every company the maximum number of director is 15. In fact, if company wants to appoint more than 15 directors, even that is possible. If company wants to appoint more than 15 directors, it is allowed. Company is required to pass special resolution for it. Okay, so if company passes the special resolution, that is approval of members, okay, special approval, then company can appoint more than 15 directors also. So here we come back to the question. So they are asking about the minimum number of persons as well as directors in public company. So for public company, minimum number of member required is, yes, it is 7, and minimum number of directors required is 3. Just now we have done. So 7 and 3, so option D is your answer. Okay, so I hope this is clear to everybody. Yeah, let's go. According to Companies Act 2013, a private company by its articles of association, which is a subsidiary company of a public company, shall be dash. Come on, see friends, a private company is a subsidiary company of a public company. Okay, let's say a public company, Tata Motors Limited. Tata Motors Limited, is it a public company? Yes, with the name itself you can easily make it out. It is Tata Motors Limited and it is not private limited. Okay, so it is a public company. Okay, now what happened is, this public company is a holding company of ABC Private Limited. ABC Private Limited. Okay. So what it is? So friends, if a holding company is a public company, subsidiary company is a private company, means the Tata Motors is holding 51% or more shares of ABC Limited, right? When one company is having shareholding of 51% or more or in another company, such company becomes holding company and such other company becomes subsidiary company. Okay, so that was the meaning of holding company and subsidiary company, right? So again I repeat, when one company is having 51% or more shares of another company, so this company becomes holding company and this company is called as subsidiary company of this company. Okay, this company is a daddy company and this is obviously a very basic, you can say this company is daddy, this company is a small baby of this company. So holding company, subsidiary company, right? Now tell me one thing, here the concept says that the holding company is a public company. This is a public company and subsidiary company is a private company. You know, so when this is a private company of this public company, holding company is a public company, subsidiary company is private company, such private company shall be deemed to be public company. That is the concept. Okay, so this private company, same thing happened here. You can see the private company which is a subsidiary of a public company, such private company shall be deemed to be public company. Therefore option B is the answer. Easy? Yes. I want to explain few things more about this. Like one point, firstly you tell me who appoints the director of company. Come on, who appoints the director of company? So obviously answer is members of company. In annual general meeting they appoint the directors, right? So tell me who will appoint the directors of ABC Limited, Private Limited. Who will appoint the directors of ABC Private Limited? Who will appoint? So again answer is what? Members. So tell me who is having the majority membership of ABC Private Limited? So answer is Tata Motors Limited. Yes or no? So in such case friends, obviously we can say that holding company also appoints the directors of subsidiary company, right? Having control and all. So this question was also asked in CSET mock test. Let's go further. So now next is, which of the following are characteristics of a private company? Private company, okay? Let's go one by one. Limited liability of members. What do you think? Is private company having this feature? Limited liability? Yes. Because private company is one of the limited companies. You have seen the name, it is ABC Private Limited. Why that word limited is coming at the end of the name of the company? Why? Friends, that is because the liability of the members of such company is limited. So therefore it is limited liability company, right? So yes, X is the right feature. Then perpetual succession. Obviously perpetual succession is for every company because every company is a corporate personality having its own existence, right? So yes, private company have this feature also. Then freely transferability of shares. So for private company this is not a feature because in private company there is restriction on transfer of shares. There is restriction on the transfer of shares. So therefore this Z option will not come. So for private company obviously this X and Y is the right thing, right feature. So correct option is option A, that is X and Y. Okay, yes. Next is liability of member in case of company limited by share under Companies Act 2013 is dash. Come on, what do you think? What is the liability of the members in case of company limited by shares? So friends, when it is company limited by shares, obviously here the members liability is going to be limited. How much liability? Limited liability. Okay, what is that? So here only we have discussed, if you remember, 10 rupees per share, application money, allotment money. Here you can see. So what is the liability? So in this case, liability limited by shares, right? So in this case, the liability of member is only up to the extent of unpaid amount on shares. Yes or no? So similarly, here also they are asking you the similar thing, that what is the liability of the members of company limited by shares. So obviously option A we can see, yes, limited to its shareholding. Option B, unlimited, that is not the case. Option A and B, not the case. None of the above, not the case. So answer is option A. Option A is the right answer. Okay, that is limited to its shareholdings. So I hope this is clear. Yes, we go to the next one. Next concept is coming, dormant company. You know what is a dormant company, friends? Yes. So before coming to the question, let me explain you first what is a dormant company. Friends, a dormant company can be summarized in the manner like, it is an inactive company. It is an inactive company. Okay. See, firstly tell me, if your company is inactive, is that okay in the eyes of law? No. If your company remains inactive, your name, your registration of company will be strike off by ROC. They will strike off your name. Okay, remaining inactive due to various reasons is not allowed. But what if you still want to remain inactive? What can you do? Like for example, you have incorporated a company today with some future goal, with some future object. So now what to do if you want to remain inactive? So friends, if you want to remain inactive, what you should do is, you have to make an application to ROC. Before ROC strike off your name, you go to ROC and you tell ROC that ROC, please give me permission to remain inactive. Please give me permission to remain inactive. And if ROC gives you the permission, that means if ROC gives you the certificate of dormant status, then this inactive company will be now called as dormant company. Yes, now this inactive company will become dormant company. Now, will your name be strike off? Answer is no, right? So now you can remain dormant. And one more thing, just for your knowledge, once you get this type of dormant status, your inactive company will be now called as dormant company, right? This is done. But once you get the dormant status, now you can remain dormant for how many years? You have already received the permission, but for how many years you can remain this inactive? You can remain dormant. So answer is, your dormant status is valid for 5 years. Maximum 5 years, not more than that. So before expiry of that 5 years time, what you need to do is, you need to either apply for active status before the 5 years gets over. And if you don't apply for active status before expiry of 5 years, then ROC will strike off your name. Okay, so that way it is. So we have just revised dormant company. We come back to the question. Minimum number of directors required in a private company under Companies Act 2013. Come on, how many directors are required in a private company? So friends, even if a company remains dormant, the number of directors requirement remains the same. Okay, so for private company, minimum number of director is 2. So answer is 2. Okay, yes. See, this was also part of CSET mock test. Next, holding company. See now what it is. As I have already explained to you the concept of holding and subsidiary company. Yes, here you can see the example, Tata Motors Limited and ABC Private Limited. Let's see the question, what they are trying to ask. A company that owns substantial share in another company to control the management and operations by influencing its board of directors is known as dash. Can you understand, friends? A company that is creating what? A company which owns substantial shares, means a good amount of shares in another company, okay, to control the management and operations by influencing its board of directors is known as dash company. So obviously the answer here is a holding company, because a holding company owns a good amount of shares in another company. That good amount is nothing but 51% or more, obviously, right? So answer is a holding company, very simple. Next, as per Companies Act 2013, a government company is a company in which government holds dash. So it's very simple, friends. The government company concept, it is talking about what? A government company means a company in which 51% or more shares are held by government. It is a company in which 51% or more shares are held by government. Which government? Central government or state government? Answer is any government. Central or state government or both together. So if they hold 51% or more shares, like for example, if there is a company, any company, and if government invest money in this company by purchasing equity, okay, government is holding how much? 51% or more shares in this company. In that case, this company will become government company. There are so many examples of government company like ONGC, Oil and Natural Gas Corporation, BSNL, BHEL, right? So all these are the government companies. So we come back to the question. Yes, so it is a company where government holds how much? So answer is not less than 51%. So option D is the right answer. So not less than 51% of the paid up share capital. This question was asked in November 21 CSET exam. Okay, let's go further. Next is, in a company, who conceives the idea of the business? Come on. Who is that person who had an idea to start the business of company? So it is very simple. See, here it says that first option is promoter. What do you think? Is promoter the right answer? Yes. Because promoter is the person who had an idea to start the company. Okay, and the definition of promoter you people will study in executive in section 2, clause number 69. That is definition of promoter. Okay, then auditor, obviously that is not the answer. Director is not the answer. Shareholders, absolutely no. So answer is A, promoter is the right answer. Right, so we are done with 25 questions till now. Yes, in this today's session we are going to cover 50 questions. Okay, in yesterday's session, that is of Indian Contract Act, we had covered 80 questions. Yes, we were revising and covering 80 questions. Today we are going to cover 25 questions. Okay, so all these questions are important as they were asked in exam earlier also, as you can see the attempts and everything, right? So please revise nicely, right? Yes, we are with you. Let's go further now, continue to the next part of today's session, right? And I hope you all are studying very well at home, right? And exams are like few days away. So please give your best. You know, the day when your CSET results will come, that result day is not going to be a less than a festival in your family. So please work for that day, so that all your family members and obviously you and us, we remain very happy on that particular day, right? And give your best shot, please. Let's go. Next question. As per Companies Act 2013, the articles of company shall contain dash. Come on, articles of company, AOA, that is rules and regulations of internal management of company, we all know. So what does it cover? Does it cover the liability of members of company? Rules of share subscription of the company, regulations for the management of company, objectives for which the company is incorporated. Okay, so friends, obviously firstly here it is very clear, it is about the rules and regulations for the internal management of company. So answer is option C, regulation for the management of the company. Okay, so done. Next one is, as per section number 7 of Companies Act 2013, which of the following documents are required for registration of company? Which of the following are required for registration? Come on, first one. Memorandum of Association. Is this a required document? Yes. In fact, the first step to register a company is to prepare MOA and AOA, because you need to submit this to ROC at the time of making application for incorporation, right? So yes, MOA and AOA is required. Next, declaration by professionals involved in company formation. Is this required? So answer is yes, even this is required, because when you make the application for incorporation of company, you need to attach MOA and AOA, and along with that you need to take a declaration by a practicing professional. That can be a practicing CA, practicing CS, practicing CMA, or an advocate. From any of them you can take a declaration, that is a declaration about compliance. Yes, in that declaration they will declare that the application what we are making for incorporation of this proposed company has been complied with all the requirements of law, right? So that type of declaration will be given. So answer is option, what is the option? Come on, 1, 2, 3, all the 3 are required. So answer is D, that is all 1, 2 and 3 is required. You can see this question was asked in CSET July 23 exam. Okay, let's go next. A company can furnish to ROC, to registrar, a verification of registered office in dash. You know friends, what is the case? See, when we prepare MOA, in Memorandum of Association, you know, we write name clause, then we write situation clause. When you write situation clause, in that, do we mention the address of registered office? So answer is no, we don't write the address of registered office, we just name the state. We just have to write the name of the state in which the registered office of company is to be situated. That's it, right? So friends, in that we are just writing the name of the state. So are we going to hide the address of registered office? Obviously no. So are we going to communicate the full address of the registered office to ROC? Yes. So how you are going to communicate it? So for communication of address of the registered office, maybe in future when there is change in the address of registered office of company, so that communication shall be done in form number INC 22. In form number INC 22. INC stands for incorporation, right? And form 22 is always used for communicating the address of company or change in the address of company, right? So option C is the right answer. Even this was asked in CSET mock test, you can see. Next is, according to section number 135, what do you think friends? Come on, 135 talks about what? 135 talks about CSR activity, right? Yes, there is only one section for CSR, that is 135. So what does it say? Come on, the board report under section 134 subsection 3 of the Act shall disclose the composition of dash. Come on, according to section 135, I'll tell you. So you know, when company conducts the CSR activity, who is the body, which is that body which prepares the policy of CSR? After preparing the policy, you know, which is that body firstly? Come on, so answer is, body is CSR committee. Body is CSR committee. CSR committee prepares the policy, then they keep this policy in front of board of directors along with the amount to be spent. Then board of director will approve that policy, will approve that plan, and accordingly they will go ahead. Okay, so you know what, the board report of the company for every financial year is prepared, and in that many disclosures are given in the board report, and one of the disclosure under 135 is CSR committee. Means if we have a company, in our company we have a CSR committee, so who all are part of our CSR committee, we need to disclose in the board report. So that's what it is saying, that the composition of CSR committee is mentioned in the board report. Okay, so I hope this is clear. We go to the next part. As per Companies Act 2013, identify the incorrect financial criteria with reference to the companies required to constitute a CSR committee that oversees the CSR activities of the company. Okay, like here we are talking about section 135 subsection 1, that is applicability criteria for CSR provisions. Okay, So we need to find out what? We need to find out incorrect financial criteria. Okay, so let's see one by one. So first they say that if a company is having turnover of 1000 CR or more during the immediately preceding financial year. So as per 135, this is a correct criteria. Or company is having net worth of 500 CR or more in the immediately preceding financial year. Even this is the correct criteria. If company is having net profit of 5 CR or more during the immediately preceding financial year, even this is the correct criteria. Okay, so company with a turnover of 500 CR or more for the past 2 consecutive years. So friends, option D is incorrect criteria. So option D is our answer. And if we revise this, so friends, which companies are required to conduct CSR activity? Which companies have to form this separate committee called as CSR committee for execution of plan? So answer is companies. Every company. When I say every company, means these rules are applicable for private company, public company, small company, foreign company, every company which satisfies any of these conditions. Which conditions? Company if having turnover of 1000 CR or more, or if company is having net worth of 500 CR or more, or if company is having net profit of 5 CR or more. So if any of this, yes, the limit, specified limits is getting satisfied in any of the companies, then yes, company have to form a separate committee called as CSR committee, and then company have to proceed with the CSR activity, right? And therefore option D is the right answer for this, because they are asking us which is the incorrect financial criteria. So option D is incorrect financial criteria, because correct one is A, B and C. So this was asked in January 2022 CSET exam. Okay, yeah, let's go to the next part. Next question is coming from CSET November 23 question paper. Okay, yes. So what it is? It is that portion of subscribed capital which has been demanded on shares by the company. Which of the following options is being referred to? Come on, what is this? It is that portion of subscribed capital. Now I need to explain you what this is. Please concentrate everybody. Firstly, you tell me, can company raise money by issue of shares? Yes, company can raise money by issue of shares. Can company raise any amount they like, or is there any limit? Yes, there is a limit. So that limit is called as what? That amount limit is called as authorized capital. It is called as what? Authorized capital. Okay, suppose, example, if authorized capital of my company is 1 crore rupees. Okay, so 1 crore rupees is the authorized capital for my company. So what is that 1 crore? 1 crore is the maximum amount what my company can raise by the issue of shares. Okay, 1 crore is the maximum amount what company can raise by the issue of shares, maximum amount. Okay, now what happened, authorized capital is the maximum limit. Right now my company is in need of only 2 lakh rupees. So will my company issue shares of 1 crore rupees? No. Right now my company needs only 2 lakh rupees. Therefore my company is going to issue shares of only 2 lakh rupees. So out of the maximum limit, my company issued shares of 2 lakh rupees. Okay. So what is this 2 lakh rupees? 2 lakh rupees is called as issued capital. It is called as issued capital because this amount, this capital amount, the shares what we have, kept in the market for sale. So what is unissued limit? So remaining 98 lakhs. This is my unissued capital. 2 lakh is issued, and this is unissued. Okay. Now see what happened. We have kept the shares of rupees 2 lakh for issue. Now what do you think? All the shares will be subscribed by the members? No. They may subscribe, they may not subscribe. So out of the issued capital, out of 2 lakhs, 1,95,000 rupees. 1,95,000 rupees, this amount, what is this? This is the subscribed capital. Shares of this amount were subscribed. So therefore this is called as subscribed capital. So what is the amount for which shares were not subscribed? That is 5,000 rupees. So this is called as unsubscribed capital. Okay, unsubscribed capital. Now see friends, people have already subscribed 1,95,000 rupees. Now people will pay the money because they have subscribed the shares, right? But you know what? Right now company has asked people to pay, out of total 1,95,000, people has asked them to pay 1 lakh rupees. Means company has given call to pay 1 lakh rupees. Yes, company told them, kindly pay this amount, 1 lakh rupees, come on all the shareholders together, you have to pay this amount. So out of subscribe, obviously you are not going to ask for money from these people because they have not subscribed the shares only. Therefore they are unsubscribed capital. You are going to ask money from these people. Out of 1 lakh, you are going to give call. So this 1 lakh rupees is called as called up capital. The remaining 95,000 you have not yet called. So therefore they have not yet given you the money. So this 95,000 rupees will be called as uncalled capital. Okay. So now this 1 lakh rupees, you can see that is called up capital. You are asking for this money, kindly pay this amount. So out of 1 lakh rupees, you have asked for 1 lakh rupees, you have given the call, but out of 1 lakh rupees, 80,000 rupees was paid by the members and 20,000 rupees was unpaid. Okay. So what is this 80,000? 80,000 is called as paid up capital and 20,000 is called as unpaid capital. Are you getting it? Paid up and unpaid. 80,000, 20,000. Easy? Getting it? Yes. Now you will be able to answer this question 100%. Come on. So it is that portion of subscribed capital. You know, subscribed capital means we are talking about what? We are talking about subscribed capital means this one. So it is out that portion of subscribed capital which has been demanded on shares by the company. Come on, subscribed and then company has demanded the money, means company has given call. So subscribe was 1,95,000. Out of this, company has given call for how much? 1 lakh rupees. So this is called as what? Called up capital, right? So answer is option D, called up capital. So I hope everybody has understood this with this example, that what it is. Yes, let's go further. Which section of Companies Act 2013 provides the provisions related to corporate social responsibility? Very simple. See, this question was asked in CSETE bulletin of ICSI July 2022. So I've already told you this many times. Yes, there is only one section for CSR, that is section number 135. So option B is the answer, right? Come on, next. Next is again CSETE bulletin July 2023. The Supreme Executive Authority controlling the management and the affairs of the company vests in which of the given authority? Come on, who is the Supreme Executive Authority controlling the management of the affairs of the company? What do you think? Who is the Supreme Authority here? Managing Director, Whole-Time Director, CEO, Board of Director. So answer is yes, Board of Director is the right answer. Board of Director is the right answer. Okay. So remember one thing, Supreme Executive Authority controlling the management and affairs of the company will be Board of Directors. Because you know, company is an artificial person. Company needs a natural person to act on its behalf. So who is that person who acts on behalf of company? So answer is board of directors. Next, come on. As per Companies Act 2013, every person proposed to be appointed as a director by the company in general meeting or otherwise has to mandatorily furnish which of the following identifiers? Which of the following identifiers? Come on. You know, basically here they are saying that every person who is appointed as a director has to furnish what to the company in general meeting. So friends, let me tell you, you know what, every person who intends to become a director of company, every person who intends to become a director of company is required to obtain DIN, that is Director Identification Number. Without DIN number, a person cannot become a director, right? And in your executive syllabus, you are going to understand how to apply for DIN and many other things about DIN. Okay, but it is compulsory for every person who wants to become a director. The DIN is required. Okay. So friends, when we talk about DIN, so here they say that every person who is appointed as a director, he has to disclose his DIN number. Yes, to the company. So, and in general meeting also. So answer is DIN number. Other options you can see, it is universal account number, personal account number, provident fund number. So you know, this is like the question which they ask in KBC, the questions which they ask for, you know, 1000 rupees, 2000 rupees, such a simple question, right? And see, this was asked in CSET January 2021. I hope this is clear. So DIN is the answer, option A. And with DIN, let me also remind you, I always say this in class also, in executive class also, that the first DIN number in India was allotted to respected Ratan Tata ji. You know, the DIN number concept was introduced in 2006 and the first DIN was allotted to Mr. Ratan Tata ji. DIN is 8-digit number, right? So that 8-digit number, the Ratan Tata ji's DIN number was number 1. 7 zeros and 1. Yes. So unfortunately, unlikely, India lost him very soon. But yes, he was very, very exceptional for all of us. Next question is, read the following statements in relation to appointment of directors under section 152 of Companies Act 2013 and choose the correct option. Yes, what is this? See, a person appointed as a director shall not act as a director unless he gives his consent to hold the office as a director. And second option says that every director shall be appointed by the company in general meeting. So what is this? So a person appointed as a director shall not act as a director unless he gives his consent to hold the office. This is a correct option. This is right. Second one, every director shall be appointed by the company in general meeting. This is also right. This was asked in CSET November 2020 exam. You know friends, every person who is appointed as a director, he will have to give the consent in writing that he agrees to be the director of company. He agrees to hold the office of director of company, right? And yes, who appoints the director of company? So answer is obviously members of company in general meeting appoints the director of company. So what are the right options? So both are correct. So therefore option B is the right answer. Let's go. Next, as per Companies Act 2013, a company may appoint more than 15 directors dash. So today in the previous questions we have already revised this. Yes, you all know that the maximum number of directors which company can appoint is 15. And if company wants to appoint more than 15 directors, in that case, company is required to pass a special resolution, that is a special approval of the members of company, right? So by passing special resolution, so answer is option A. By passing special resolution, company may appoint more than 15 directors. Very simple. Next one, Who has the authority to decide the remuneration of the first auditor of the company? Come on, who decides the remuneration of the first auditor of the company? Come on, the central government, the board of directors, then the auditor themselves, and the member at general meeting. Come on, who decides the remuneration of the first auditor? What do you think? So obviously answer is, friends, when we talk about appointment of auditor, remuneration of auditor, these are considered as the ordinary business of company. This is considered as what? Ordinary business of company. And ordinary of business of company is transacted in annual general meeting. Right? There are 4 types of activities which are considered as the ordinary business. First is appointment of director, appointment of auditor and their remuneration. Third one is adoption of financial statement, and lastly declaration of dividend. Right? So what is the answer? Who decides the remuneration of the first auditor? So answer is the members at a general meeting, as this is your ordinary business of company. Yes, next is, as per Companies Act 2013, every listed company and a company belonging to other class of company as may be prescribed shall annex with its board report a secretarial audit report given by dash. This question is again coming from CSET, January 23. What is it? See, firstly friends, here a word is given, secretarial audit. So what is secretarial audit and who does it? So friends, let me tell you what it is. Friends, what it is. See, firstly, the audit, very well, you must have heard about the accounts audit, but I am talking about secretarial audit. Secretarial audit means audit of compliance. Like if there is a company, there are so many different acts which are applicable on a company. Yes, so different acts, different rules are applicable on a company. So is that company following all those acts? So we conduct audit for that. So that audit is called as what? Secretarial audit. Obviously that audit will be conducted by a professional. Which professional? A professional which is considered as the legal advisors for the company, compliance officer of the company. So obviously this type of audit is conducted by the practicing company secretary. So who conducts this type of audit? So answer is company secretary in practice. Okay, so option B is the answer. Next, as per Companies Act 2013, KMP in relation to a company means one or all of the given below. Identify the correct option. Come on. KMP in relation to company. So again here we need to go with what? We need to understand the definition of KMP, as we have done earlier also. The definition of KMP is given in section 2, clause 51. Okay, so come on. So CEO, Chief Executive Officer, is a KMP. Yes. MD is a KMP. Yes. Manager is a KMP. Yes. CS is a KMP. Yes. Whole time director is a KMP. Yes. Chief Financial Officer is a KMP. Yes. So what is the correct option? So yes, all 1, 2, 3, 4 are the KMP of the company. And again you can see this was asked in CSET January 2022 paper. Right? So very simple. We go to the question number 40 now. Come on. As per section 149 subsection 10 of Companies Act 2013, subject to the provisions of section 152, an independent director shall hold the office on the board of a company for a term up to dash. Come on, friends, independent director is one of the type of director, correct? But every person cannot become an independent director. Independent director means a person who satisfies the eligibility criteria which is given under section 149 subsection 6. 149 subsection 6, yes. Because independent director is a person who is unbiased, who is not going to take the favor of company, who is not going to take the favor of investors also. Right is right, wrong is wrong. He is going to be unbiased. So for acting as an unbiased person, for acting like an independent person, he will have to satisfy the certain eligibility criteria, right? Like for example, he or his relative may not have a connection with the company, company's holding company, company's subsidiary company, company's associate company, and so and so. So there are eligibility criteria, and it is not that he should not have any connection only. He may have connection, but that connection should be only up to the extent which is given in law, only up to the extent which is permitted by law. So basically there are eligibility criteria for becoming an independent director which are given in section 149. Yes, section 149 subsection number 6. And this type of independent director, yes, if they are appointed in certain companies only, there is applicability criteria for independent directors appointment also. Like for listed company, it is compulsory to have, out of the total number of directors, at least 1/3 shall be independent director. It is compulsory for public listed companies. What about other companies? So it's not other companies, it is other public companies, that is public unlisted companies. Even they have to appoint independent director, but only if they satisfy the required conditions, right? So yeah, for private companies there is no need to appoint independent director. So friends, these independent directors are appointed for how much tenure? What is the tenure? So tenure is 5 years. So answer is 5 consecutive years. However, just for your knowledge, once they complete this 5 years, they are also eligible for reappointment for another 5 years also. Okay, so they are appointed again by the shareholders, right? So this question was asked in again January 22 CSET exam. And now we move to the last 10 questions of today's session. Let's go. Which section provides that where there is no provision made in articles of association of company for the appointment of first director, then subscriber to MOA who are individuals shall be deemed to be the first director of the company until the directors are duly appointed by the member. So friends, firstly here we are talking about a concept of first director of company. Okay, what is that first director concept? So friends, you know who is the first director of company? So if we revise this, the first director shall be a person whose name is mentioned in articles of association, whose name is mentioned in AOA as first director. So whoever person's name is written as a first director in articles of association will be the first director of company. But sir, what if the name is not mentioned in AOA? If no name is mentioned in AOA, then who will be the first director? So in such case, subscriber to memorandum shall be the first director of company. Subscriber to memorandum means first members of the company. The people, the members who signs the MOA shall be the first director of company until the members appoint a different director, right? So all this explanation and this everything is given in which section? So this is section related to first director is section number 152. Okay, so that is your answer, and this was again coming from e-bulletin November 2022. Okay, so we move further. As per Companies Act 2013, in case the articles of public company do not provide for the retirement of all directors at AGM, then what fraction of the total number of directors shall be liable to retire by rotation? This was asked in CSET July 23 exam. Please understand what I am going to say now. Friends, the topic is about retirement of directors. Retirement of directors by rotation. Okay, so retirement of director by rotation, you know friends, there are two types of, generally the rules related to retirement of directors is given in the articles of association of company, and if nothing is given about retirement of director in AOA, in such case you have to follow what is given in Companies Act. right? So what is given in Companies Act? Companies Act says that there are two types of directors. Okay, there are two types of directors. One, director who are liable to retire by rotation. Okay, and there are also directors who are not liable to retire by rotation. Okay, so there are two types of directors. Directors who are liable to retire, I am saying liable to retire. Okay, means I am not saying they will actually retire, they are liable to retire. So how many directors are liable to retire and how many are not liable to retire? How many are safe? So directors who are liable to retire are 2/3 of the total number of directors. 2/3 of the total number of directors are directors who are liable to retire, and directors who are not liable to retire are 1/3. Yes, they are 1/3 of total, that is remaining ones. 1/3 of total. Okay. So friends, here you can see the question they have asked is, in case the articles of the public company do not provide for retirement of all the directors at AGM, what fraction of the total number of directors shall be liable to retire? We just need to explain here how many directors will have to actually retire, liable to retire. How many directors are the directors who are liable to retire? So tell me how many directors are liable to retire, what fraction? So answer is 2/3. So 2/3 of the total number of directors are liable to retire by rotation, right? So here you can see the options: not less than 1/3 of total number of directors, not less than 1/4 of the total number of directors, not less than half of the total number of directors, and not less than 2/3 of the total number of directors. So obviously answer is option D. Option D is the answer. Also, I want to explain this further. So just now I told you the total number of directors who are liable to retire is 2/3. Okay, but how many directors minimum will have to actually retire by rotation? How many directors will have to actually retire? These are the directors who are liable to retire. Means these are the directors 2/3. They are liable to retire, means they are in danger zone. Okay, but minimum directors will have to retire by rotation. Minimum director who shall actually retire by rotation is 1/3 of the directors who are liable to retire. Yes, actually number of directors who shall retire, actually retire. In the question they have asked you how many directors are liable to retire. Therefore we have marked D is the option. But how many directors which actually have to retire? Minimum number of directors will actually have to retire is 1/3 of that 2/3. That is 1/3 of the directors who are liable. So 1/3 of 2/3. So whatever is the answer, those directors will have to actually retire by rotation. Okay, so that is the point. I hope this is clear to everybody. This first question was asked in July 23 exam. Yes, come on, next. Next question is, I hope everybody has understood the example. This one, right? Come on. As per Companies Act 2013, how can a director of company be removed? See, when we talk about removal of director, that means we are recollecting section number 169 of Companies Act 2013. See, you tell me who can appoint a director of company? Who can appoint a director of company? Obviously the members, correct? So who can remove a director of company? Again answer is members. You know what? A director is removed. Okay, removed means what we are talking about. Removal means we are removing a director before expiry of his tenure. Okay, so A directors can be removed by the members, as I told you in the general meeting. A director can be removed by the members by passing what type of resolution? Ordinary or special? So answer is director can be removed by the members just by passing ordinary resolution. Just by passing what? Ordinary resolution. I hope this is clear to everybody. Yes. So friends, here you can see how can a director be removed? So answer is yes, by passing a ordinary resolution in a general meeting. Remember this. Okay, now you tell me, if company wants to remove an independent director, then what to do? Come on. If company wants to remove an independent director, then company is required to pass what? Friends, if company wants to remove an independent director, then company is required to pass ordinary resolution only. Then also answer is ordinary resolution only. Yes. But if company wants to remove an independent director who is already reappointed, means an independent director is appointed for 5 years, right? After 5 years, he can be reappointed for another 5 years, right? So if company is removing an independent director, it can be done just by passing ordinary resolution. Same as this. All directors can be removed just by passing ordinary resolution only, right? But an independent director who is reappointed, means the independent director who has already completed his 5 years term and now he is reappointed for another 5 years. Such type of independent director can be removed by passing special resolution. For independent director, it is ordinary resolution, okay? But if it is reappointed for another 5 years, then it is special resolution. Remember this, please. Okay, I hope this is clear to everybody. Yes, come on. Next question. See, this question was asked in CSET November 2020. Now, question from CSET January 2023 exam. Yes. So it is the capital that refers to the funds that a company raises. Come on friends, funds which company raises in exchange for issue of ownership interest in the company, okay, in the form of shares, and may also describe the number and types of shares that compose a company's share structure. Which of the following options is being referred to? You understood what they are talking about. They are talking about the funds which company raises. They are talking about the funds which company raises, okay, which company raises by issuing ownership, that is in the form of shares. Means they are talking basically about which is that capital which company raises by issue of shares. So very simple answer is share capital. Share capital is the capital which company raises by the issue of shares. Easy. See, this was exam question. You can see CSET January 23 exam paper. Yes. Next is yes. Next question is about the meetings. Notice for calling a statutory meeting of company should be given within a period of not less than dash. Come on, how many days prior notice is required to be given to call a meeting of company? Anyone? You know friends about meetings, you know, see there are two meetings, board meeting and general meeting. To call a board meeting, company is required to give at least 7 days prior notice. Company is required to give at least 7 days prior notice. To call a general meeting, company is required to give at least 21 days prior notice. Are you getting my point? At least 21 days prior notice. So here we are talking about, yes, 21 days prior notice. Minimum 21 days prior notice is required to be given to call any general meeting. So answer is 21 days, option A. Then An application seeking extension of time to hold AGM of company should be made to dash. You know friends, for calling an annual general meeting, for holding an annual general meeting, the rule is, see, the first AGM of company shall be conducted within 9 months from the end of a first financial year. From the end of first financial year, okay? So within 9 months from the end of first financial year. Then subsequent meetings, second and subsequent AGM, every year AGM is conducted, right? So for first AGM within 9 months from the end of first financial year. It is not 9 months from the date of incorporation. Please make sure this. Okay, so it is within 9 months from the end of first financial year. Then the second meeting, third meeting, fourth meeting, then every year company have to conduct within 6 months from the end of every financial year. It is 6 months from the end of every financial year. So if a company asks you, tell me within how much time meeting is to be conducted. So answer is 6 months from the end of every financial year. Okay, but you need to take care of one more thing. It is not just one condition, there is one more condition. It is within 6 months plus you also need to check the gap between two AGM. It should be within 6 months from the end of financial year plus the gap between two AGM shall not exceed 15 months. The gap shall not exceed what? 15 months. Now due to some reason, if your gap is exceeding 15 months, can you ask for the extension? Yes, you can ask for extension of time. Right friends? So for this extension, you need to make a request. You need to make a request to whom? You need to make a request to ROC. And then you may get an extension of maximum 3 months. Right? So question is about, for application seeking extension of time to hold AGM shall be made to whom? So answer is ROC. So option B is the right answer. Very simple. Next one. A quorum is dash. So friends, whenever we talk about board meetings, we talk about general meetings, quorum is very important. You will study quorum in detail in executive also, right? So what is the meaning of this word quorum firstly? Quorum means minimum number of members required to conduct a meeting. Like there are so many members in the company or so many directors are there in the company. But when the meeting was conducted, only few members came. So can we start the meeting with such few members? So answer is, you need to see is quorum first. Quorum is required. Quorum means minimum number of members required to be present to start the meeting. So here you can see they are asking you the meaning of quorum. So quorum means what? A list of securities owned by a person, one who acts on behalf of another, person who owns the business, or minimum number of members required to be present to transact business at the meeting. So obviously answer is option D. So D is your answer. Next is, dividend of company is declared in dash. Friends, I have an interesting question for you. Firstly, you tell me who declares the dividend of company. Come on, who declares it? Write your answer in chat box. Who declares the dividend of company? Yeah, obviously you people will be writing, sir, board of directors. Correct? But that is the wrong answer. You know, dividend is declared by the shareholders. Yes, dividend is declared by the members of company, shareholders of company in annual general meeting. You know, today while revising I told you AGM, what is discussed in AGM? Only ordinary business is discussed in AGM. Ordinary business means what? Only 4 things. That is appointment of director, appointment of auditor, adoption of financial statement and declaration of dividend. So declaration of dividend is an ordinary business of company and it is declared by the shareholders. It is declared by the members of company. Yes, you know what? Dividend is recommended by board but declared by shareholders. Who recommends in the meeting? the amount of dividend which is proposed to be declared. So it is recommended by board. It is recommended by board. Okay. See, because board of directors are running the business of company. So dividend is nothing but a part of profits. Yes. So who will know about what is the financial status of the company? Like if out of this profit, how much amount we will need in future? So answer is board of director. Therefore, out of the profit, a certain amount board recommends in the meeting that this much amount is good for the company if we can declare in the form of dividend. Remaining amount we need to keep in reserve. So it is recommended by board, but it is declared by the shareholders in AGM. So you know the answer now. It is declared in what? Annual general meeting. Yes. Okay. Sir, but if the members are declaring the dividend, sir, members will declare X amount, any amount they like, because the dividend is the benefit which is given to them only. So sir, they will demand any amount they like. So can they do that? Answer is no. Because Companies Act 2013 says, Secretarial standards says that the members of company cannot declare dividend more than what is recommended by board. I am explaining you this only for your knowledge, don't worry. Okay. So the members of company declares dividend true, but members cannot declare dividend more than what was recommended by board. Okay, so that was the case. So answer is basically AGM. Next, as per Companies Act 2013, every officer of company whose duty is to give notice of board meeting fails to do so shall be liable for a penalty of dash. This was asked in November 22 exam. Right? See friends, when we talk about board meeting, it is whose duty to send, say for board meeting you are going to invite whom? For board meetings you are going to invite the board of directors. Right? So who is that person who is duty bound to send the notice of board meeting, to send that invitation? So answer is, the person who was duty bound to send the notice of board meeting is CS or director or person authorized by the board of director. CS or director or person authorized by the board of directors. Any one of them can send the notice of board meeting to the board of directors. So whoever the person was duty bound, whoever was responsible to send the notice, if he fails to send the notice, then what is the penalty? So penalty is 25,000 rupees fine. So penalty for such person is fine of rupees 25,000. So please keep this in mind. Right? So I hope this is clear to everybody. And now we come to the last part of today's session, that is question number 50, the half century question. And this question has to be very special because you can see this question was asked in January 23 exam. Okay, so what is the question? Come on. As per Companies Act 2013, CSR committee shall perform which of the following functions? Which of the functions will be performed by CSR committee? As I told you, CSR committee, its job is to look after the execution of the plan, to prepare the plan, CSR plan, where the money will be spent, how much amount will be spent. So they prepare the policy and they keep the policy in front of board of directors. Board of directors will approve it, and then after forming the plan and everything, they will look after the execution. So let's see which of the following functions CSR committee performs. The first is to formulate and recommend to the board a CSR policy. Right? Obviously, is this the part of functions of CSR committee? Answer is yes. To prepare the policy and recommend it to the board. Then recommend the amount of expenditure to be incurred on the activities carried out by CSR committee. Do they have to recommend any amount? Yes, they recommend the amount also after calculating that 2% of average net profits made by the company. Then decide the remuneration of managing director taking care of compliance of CSR activity. No. This is not the job of CSR committee. So this is not the case. So what is the functions? What are the functions? So answer is 1 and 2. right? So answer is option A. 1 and 2, only 1 and 2, these are the functions of CSR committees. So friends, yes, with this we are done with the half century. Yes, we have discussed 50 questions. This is the end of today's session, Yodha series. But friends, all my dear friends, I request you to please solve all these MCQs. And if you think that these sessions are important, we really work for you. So please just hit a like button and just put a comment. You can just say thank you to us. That is the only consideration we expect from you. And very, very, very good wishes. All the best for your CSET exam. And yes, my part is over. I was going to cover these 2 chapters. But I want all of you to watch all the chapters of all the subjects and please solve maximum MCQs, and see you all in CS Executive very soon. I know you all little soldiers are going to work very hard. Thank you so much. All the best. Thank you so much. Bye-bye.